All rise.
The Kosovo Specialist Chambers is now in session.
Thank you. Good morning. Good morning, everyone. So today we are resuming the appeal hearing concerning Mr. Mustafa's appeal lodged against the trial panel's judgment of 16 December 2022. We will proceed as follows, and the schedule has changed a little bit since it was originally set. So we will hear first the SPO for 15 more minutes, as we decided yesterday, so you can have the opportunity to speak about the sentencing. So that will be until 9:45. From 9:45 until 11, that is during 1 hour and 15 minutes, we will hear the victims' counsel. Then at 11, we will take a pause of 30 minutes. From 11:30 until 12, we will hear during 30 minutes Counsel Van Bonnet to hear his final submission. And then 10 minutes from 12 to 12:10 to hear Mr. Mustafa. And then we shall conclude the hearing. And before I give the floor to the SPO, I ask the parties and victims' counsel to provide the panel with electronic copies of any national jurisprudence to which they refer in their briefs or oral submissions at the earliest convenience following the hearing, and additionally, as relevant, any English translations in your possessions would be appreciated by the panel. So I invite now. Forgot to call the case, but the case will be called now.
Good morning, Your Honors. This is the file number KSC CA 2023-02, the Specialist Prosecutor versus Salih Mustafa. Thank you, Your Honors.
Thank you. Sorry about that. So we shall hear now the SPO during 15 minutes.
Extra time. The one issue that I didn't get to yesterday was the issue of mens rea for murder, and Your Honours asked questions about that in your order F30. And the first question that Your Honours asked was, what kind of intent is required for the charge of murder? And our response to that is that the mens rea for murder is settled. The elements are either an intention to kill or willfully causing serious bodily harm, where the perpetrator should reasonably have known that the act or omission might lead to death. So it's intention to kill or willfully causing serious bodily harm with the requisite awareness. The second question that Your Honours asked was, how is the applicable intent to be defined? And in our submission, this is not a question that Your Honours need to resolve in this case, because the trial panel reasonably found that Mr. Mustafa and his BIA subordinates intentionally killed the murder victim. And Your Honours should first assess whether the trial panel's findings of Mr. Mustafa's intent is erroneous, meaning that the trial panel's evaluation of the evidence is wholly erroneous, or that such evidence could not have been accepted by any reasonable trier of fact. And in particular, Your Honour should assess whether Mr. Mustafa's intent cannot be inferred on either of the two alternative limbs of the mens rea standard. In other words, of course, the trial panel found that he had an intent to kill, but unless the evidence could not establish that he had at least a willful he had at least an intent to cause serious bodily harm, where he should have reasonably known that his acts or omissions might lead to death. Unless Your Honours are satisfied that the evidence could not establish that, then Your Honours need not concern yourselves with the definition of intent. And in our submission, the evidence establishes unequivocally that Mr. Mustafa had at least an intent, he at least willfully caused serious injury with an awareness that, that this might lead to death. And there are numerous factors in the trial judgment from which that can be inferred. The first one being Mr. Mustafa's presence at the compound, and this is a small compound. His direct participation in the mistreatment of other prisoners, including the use of a firearm, the use of a baseball bat. So from those aspects, one can infer both knowledge and also a volitional element. The specific targeting of the murder victim by direct subordinates of Mr. Mustafa. The decision not to release him or to evacuate him, which the trial panel found could only have been made by Mr. Mustafa. The motive to prevent the murder victim from reporting because he knew many of the people involved. The subsequent expressions by Mr. Mustafa to frustrate proceedings. And again, I emphasize that the most favorable version to Mr. Mustafa, the most favorable version, is that he abandoned a man who could not walk and who was close to death. A man under his care, a man under his custody. And from that, it must be inferred that he had at least an intent to cause serious bodily harm, which he ought reasonably have known might lead to death.
We have a question for you.
Yes.
Yes, good morning. On the question of intent, two questions. In 688, the trial panel defines the intent required, intentionally or willfully caused. We do not have a general intent definition in our law. Would you consider that a lesser degree of intent than direct intent, i.e., for example, dolus eventualis, is within our law? First question, okay? Lower than direct intent. And the second question is as to the defendant's knowledge of the condition of the murder victim. Can it be inferred from the trial judgment that the defendant was aware of the conditions of the murder victim? And when, if this is so, from what can it be inferred? Thank you.
Yes, to answer your first question, there is some authority for the proposition that intention to kill also includes something lower than meaning to bring about that result. That is a recklessness, often or sometimes referred to as a recklessness standard. The ECCC appeals chamber in the case 2 in that case established that an intention to kill also includes recklessness or dolus eventualis. The Carradage trial judgment came to a similar finding. The references there are the non non cure, the case 2 judgment at paragraph 390 to 410, the appeals judgment, and the carriage trial judgment, paragraphs 447 to 448.
Just, Mr. Bane, why is this relevant for us? I think I refer to we have a law, and we have, of course, Kosovo law as a kind of fallback. Why don't you apply the Kosovo criminal law to define the intent? Why do you refer to ICTY case law?
Well, because, Your Honour, you're applying customary international law, and in our submission, the Kosovo, substantive Kosovo criminal law, even though we're a Kosovo institution, the substantive Kosovo criminal law has no more bearing on the definition of the mens rea of murder under customary international law than any other domestic criminal law. So, and again, I've referred to Article 3, which guides Your Honours as to how to resolve the interpretation of customary international law. And then, again, you can go to the Statute of the International Court of Justice, Article 38, and following those hierarchies or those sources, my submission, the judgments of the ad hoc tribunals are far more persuasive than the substantive criminal law of a single jurisdiction. To answer your second question, essentially, well, it's an inference. Mr. Mustafa's knowledge is inferred, but it's inferred from a range of factors, a range of persuasive factors, and some of them I mentioned before. First of all, he's present during key periods of the murder victim's detention. He's present the day that he arrives, and he's present during multiple times afterwards, and he's present by his own admission a few days before he's released. And the trial panel found that the decision to release and the decision not to evacuate and the decision not to provide medical care could only have been made by Mr. Mustafa. And from that, one can infer, or that has to be based on knowledge of his detention. One can safely infer from that that he knew something about the condition of the murder victim. And again, this is a small compound. There are only a small number of prisoners there. And given the layout of the compound, the only reasonable conclusion is that he must have had sufficient knowledge of this man's detention, who was, in the trial panel's words, lethally mistreated, who was close to death. And at that point, on the version most favorable to Mr. Mustafa, he's left a man who cannot walk and who's close to death in a situation where everybody else is evacuated, where that person, again, is close to death. And in our submission, that can only lead to the conclusion that he must have known about his condition, and he must have known about the consequences that would ensue.
Thank you.
Yes, just to wrap up the point about the submission about the mens rea. In our submission, even if Your Honours were to depart from any of the jurisprudence interpreting what intent to kill means in our submission. It would not change the outcome because, at the very least, Mr. Mustafa was willfully causing serious bodily harm, which he should reasonably have known might lead to death. Yes, unless there are any further questions, I hand over to Ms. Lawson.
No, and we went over time. And are you finished now, or you still want to make some oral submission about sentencing, or?
If we're in the court's hands, Your Honor. We're in the court's hands. I believe.
You have some minutes to.
Thank you, Your Honor.
Good morning, Your Honours, and we're grateful for the additional time. On sentencing, in respect of the constitutional submissions made yesterday, I would refer the panel to paragraphs 32 and 33 of filing F00262 in the Thatchi et al. Case. There we discuss those constitutional provisions and explain that because the KSC law addresses customary international law crimes, there's no conflicting sentencing regime in Kosovo which could be globally understood to apply. And there are also related relevant findings of the appeals panel in IA 009 F 00030, including in particular at paragraphs 39, 56, and 57. That said, I will turn briefly to the order posed, to the question posed in the order issued by the panel. The sentence of 26 years imprisonment is fair and proportionate, and proportionality in this context refers primarily to the relationship between the gravity of the offences and Mr. Mustafa's responsibility for them. That is his blameworthiness. The trial panel made that assessment carefully in this case, making a number of significant and distinguishing findings. The defence has made a bare assertion that for the same type of crimes, no sentence of this length exists in international tribunals. There are a number of reasons why this fails to demonstrate error. Primary amongst them is, of course, the trial panel's overriding obligation to tailor a penalty to fit the individual circumstances of the accused and the gravity of the crime. And properly evaluating those factors, including any relevant aggravating or mitigating circumstances, means that sentences can vary substantially, even where they relate to the same type of crimes. It's not often possible to just transpose a sentence from one case to another, and we noted relevant jurisprudence on this point in our brief, including the findings of this panel at paragraph 434 of the appeal judgment in the Guchati and Haradinaj case. In order to raise an inference that a sentence may be capricious or excessive, it would have to be out of any reasonable proportion with a line of sentences passed in similar circumstances for the same offences. No such line of cases has been identified. Even yesterday, not a single case was identified despite the panel's invitation. Nonetheless, if a comparison exercise is to be conducted, we would make 2 points. First, regard should be had to the applicable sentencing range, as indeed Your Honours did in the Guchati appeal. It would have been open to the trial panel in this case to impose a sentence of life imprisonment. As was correctly noted by the trial panel, under Kosovo law at the time, war crime offences were eligible for the harshest available sentences. And in consideration of the inherent gravity of the crimes at issue, the existence of multiple aggravating factors, and Mr. Mustafa's very high level of contribution to those crimes, the sentence imposed by the panel was in fact at the mid-range, perhaps the lower end of the mid-range of what was actually available to the trial panel. Second, a comparison should not be confined just to international tribunals. In current practice, it's likely that the majority of international crimes are now being prosecuted before domestic courts, and they're being punished with sentences commensurate to the gravity of those offences. Simply by way of example, Chucky Taylor is currently serving a 97-year sentence in the United States, having been convicted for acts of torture and conspiracy to commit torture. That sentence is comprised of a number of consecutive terms, but even broken down to its component parts, we see that, for example, count 1 alone, a charge of conspiracy to commit torture, attracted 20 years, while counts 5, 6, and 7, each relating to the torture of one individual victim, attracted 10 years each. That's United States versus Belfast, and we will provide a copy in line with Your Honour's direction. In 2021, a Dutch court imposed a sentence of 20 years on a Syrian man for the war crime of murder. And significantly, that sentence related to a single murder without the added gravity of running an illegal detention centre where multiple vulnerable civilian victims were detained, threatened, and tortured. And the UK Court of Appeal upheld a life sentence for the killing of 2 persons as war crimes. And again, we will provide copies and references of each of these. However, the same caveats that I mentioned in relation to international jurisprudence also apply to these domestic cases. We're not drawing a direct factual comparison. Our point is simply that the submission is both overly simplistic and not accurate. It's certainly not a basis for finding any abuse of discretion by the trial panel. And our final point. We do not consider that the sentence should be significantly or at all impacted, even in the event Mr. Mustafa's conviction on one of the charges were to be overturned. The panel's factual findings on the gravity of the accused's criminal conduct, his individual circumstances, and mitigating and aggravating factors are not materially affected, even if a specific element of any particular crime is not found to be proven. This is consistent with the case law of international tribunals, where overturning certain convictions, even for serious crimes, does not necessarily result in a reduction of sentence where the affirmed convictions are still for very serious crimes. The Renzeo appeal judgment, paragraphs 620 and 621, are examples of this. And it is the case that that applies in this instance, where, for example, the offence of torture, which was committed with particular cruelty, and in which Mr. Mustafa directly committed offences against 2 victims, fully warranted the 22-year sentence imposed for that count. These are our submissions, Your Honour. Thank you very much.
We have one question for you.
Thank you very much. My question refers to Article 44 and para 781 of the trial judgment. We do not really have sentencing ranges. What we have is an upper limit in 44 para 1. And so to get to a concrete sentence, either you refer to what you would call customary international law, i.e. case law of other tribunals, or you refer to Kosovo law. In Article 44.2, it is said, we shall take into account the Kosovo law and any subsequent more lenient sentencing range. The trial judgment in this paragraph, paragraph 781, referred to the former Yugoslav code, but it did not compare this sentencing range in this code to the sentencing range in the currently applicable Kosovo law. Is this for you, is this okay for you, or do you see any problem in terms of our 44.7.2 of the European Convention, Lex Meteor?
Your Honour, the trial panel found that subsequent Kosovo law applied either similar or higher lowest minimum sentencing.
Where did it find? Where did it find? I didn't find this. That would have been very helpful. Where? In 781, I didn't find it. No footnote. Where exactly did it make this comparison?
This was at so, Your Honour, it was the footnote to that same paragraph, footnote 1629, where the panel also notes that subsequent relevant laws or codes adopted in Kosovo provide equal or more severe sentencing ranges.
Okay, thank you.
Thank you. So that concludes your submission. So I would like to invite now the counsel for the victims. You have more than 1 hour, but the idea would be to take a pause at 11. So if you need more time, perhaps we can continue after the pause.
Good morning, Your Honours, first of all. Good morning, everybody inside and outside this courtroom, and thank you very much for giving me the floor just to provide you with an indication and to allow for a bit further planning for everybody. I will not need an hour or even an hour and 15, but will be much shorter. I've actually indeed rewritten everything after yesterday's hearing in order to ensure that we do not duplicate any submissions. But let me first get the lectern, set myself up, and then I'm ready to go. Your Honours, the victims participating in this case are hoping that this hearing will be the penultimate step for them in finding closure. When this trial started, I emphasized how long they have been waiting for justice to be done. And now we are finally, hopefully, getting to a point where an end may be in sight. The SPO, as I've just said, has made extensive and very substantial submissions on the questions posed by Your Honours, and therefore there is no need for me to reiterate, for example, much of the case law on questions of causality and the substantial contribution standard. The SPO Council have also reiterated some key findings by the trial panel of relevance and important aspects of what the evidence brought to light throughout the trial. I do not want to make any repetitive submissions here. What has become clear, though, just to put it all back into context, is that international case law, as well as major legal systems around the world, all require a causal link between an action or omission of an accused with the death of a person in murder cases. And equally, the Kosovo criminal law applies the notion of conditio sine qua non, and therefore can firmly be placed within precisely those practices. But it is also clear, and we've reviewed that, that this attribution is subject to a normative correction based on what is ultimately and has well been broken down to questions of what is reasonable and what is fair. And this is what I want to focus on today with regard to this key sticking point in the appeals proceedings, the murder charge. It is critical for the indirect victims participating in this case to have acknowledgement that their loved one was not only a victim of torture, but that his loss of life was the result of murder. Which brings me to this question posed by Your Honours to the SPO during yesterday's hearing. Would it be fair and would it be reasonable if we attribute the murder of the victim to Salih Mustafa, even if the final blow may have been delivered by enemy Serbian forces? Now let me remind the audience, everybody here, that this assumption is more of a hypothetical exercise, but it is one that the law requires. Indeed, it is a rule that if in doubt, the facts of a case must be assessed in the most favorable way to the accused. So would it be fair? Would it be reasonable if Salih Mustafa's conviction for murder is upheld? And here, from the victim's perspective, there's only one answer, and that is a resounding yes. Loud and clear. Yes, it is the only reasonable and fair conclusion. And let me explain why. To do so, I want to take you back to the day when I traveled to Kosovo and also visited Salih when I first took on this case in 2021. I've been up there, and I can tell you it's a very isolated place. High up in the mountains. This place is surrounded by fields and woods. Your Honours have seen some of the imagery yesterday. It's very rural. Now there are roads, but this wasn't always the case. One can only imagine what it's like if you are left out there, if you have no place to go. There is nothing to help you. There's nothing to shelter you. Certainly not if you are gravely injured, with all limbs broken, and that in a situation of war, of advancing enemy forces. And these are the facts that the trial panel established clearly, beyond reasonable doubt, that this was the situation in which the victim found itself. The murder victim was a young person who was, up to the point when the KLA detained him, a healthy young man, nowhere remotely near Salih. It was the detention, the torture, the abhorrent treatment by Salih, Mustafa, and his men that made the victim not just a very vulnerable human being, but someone who was no longer at all capable of fending for himself at all. A man with broken legs, with broken arms, with flesh that already smelled because of the severity of his injuries. He was malnourished and massacred. Leaving this person in a place like Salih, where there is no help available, where there is nothing that anybody in that situation could possibly do to escape from death. It is this situation we have to look at. And this is the situation that is fully attributable to Salih Mustafa. It's only his actions that put the victim in this situation. To Salih Mustafa, it's attributable as a perpetrator of murder, as the commander and as the leader of the beer unit, which, under his supervision and command, delivered torture and ill treatment day by day. The murder victim would not have been, as I've said, anywhere near Salih, nowhere near any other dangers there at that point in time if it hadn't been for Salih Mustafa. And this is why it is fair and also reasonable to attribute his death, this murder, to him. Anybody who leaves someone behind in that situation, in the path of advancing enemy forces, forces known for persecuting the Kosovo Albanian population, not just would have known, but knew that this was a death sentence. It nearly wouldn't have mattered if it had been, say, a pack of wolves, bears, enemy bullets, shells. We yesterday discussed case law, and there was this question whether there's a distinction between what nature does or what enemy forces do. There is a point when, as long as it is a clear, inevitable scenario that will unfold, that this distinction becomes moot. Salih Mustafa knew and certainly foresaw that leaving someone like that there and then would lead to his death. As a reminder, we heard by actually a defense witness, Toita Hadri, that it was Salih Mustafa who organized, on the day when the murder victim was left behind, the evacuation of others present in Salih. He was the one who saw the danger and who was busy helping people escaping from that, bar two, the murder victim and one other person left behind. It cannot be emphasized enough that it was no entirely new, autonomous event that materialized here. If we work, again, in my view, more hypothetical than anything else, but if we work on the assumption of Serbian fire as a cause of death, that was foreseeable. And only for the avoidance of doubt, and as a reminder, this is not the probable scenario here. Indeed, it is the least likely, but as I've said, it is the one most in favor of Salih Mustafa. The danger was clear. The whole point of evacuating Sludge, this detention compound, was to protect those present in Sludge. So if you do so for everybody but 2 gravely injured people you leave behind, them being hit possibly by Serbian bullets does not constitute a new, autonomous, free event that can break the chain of causation. It would not diminish criminal attribution in this case. Let me now, just for a moment, take a step back from Salih Mustafa and the facts of this case, and all the case law that was so thoroughly covered in the SPO's presentation yesterday. The war crime of murder of all kinds in non-international armed conflict, exists because it is a grave violation of common Article 3 of the Geneva Conventions. This war crimes provision exists to enforce compliance with international humanitarian law. It exists and is designed to do one thing, which is to protect the civilian population from the dangers that such war poses. It is the dangers of civil war, of non-international armed conflict, of any war indeed. In many ways, non-international armed conflicts are probably the most dangerous of circumstances for civilian populations, because war is brought to the doorsteps in one country and not on the classic battlefield. It's in the villages, it's in the most remote rural compounds as well as in the cities. So we must bear in mind that the war crimes provision that we are debating here is a criminalization of those violations of Common Article 3. And if we were to deny attribution in a situation as the one at issue here today, it would become so easy for a perpetrator to absolve themselves of murder of any kind in this kind of wartime situation. All they would have to do is do enough, it's just enough. Torture, injure, just to the extent that then the enemy forces are doing the rest. Just enough to get rid of those civilians they want to have finished off. If we were to raise the attribution bar to such standard that we attribute foreseeable enemy fire, then you ultimately allow situations to go unpunished as murder, in which you use and turn enemy fire into your own murder weapon. And you can absolve yourself for that responsibility, of that responsibility. It would leave the danger of rendering this war crimes provision ineffective. And this cannot be a reasonable result. Any interpretation of the law must aim to give effect to the object and purpose of the provision. And the object and purpose of the prohibition of murder of all kinds in Common Article 3 is to protect civilians from the dangers of war and the heightened risk of murder, of being killed in these wartime situations. Let me now from here also briefly look at the further aspect of intent that you discussed this morning. And we've heard of international case law, and you quite rightly ask, why not look at Kosovan law? And actually, indeed, it's pretty clear. Kosovo, the Kosovo criminal law in Article 21 clearly provides for lesser than a direct intent. Now let me see. Can't move the screen. So Article 21 says that a criminal offense may be committed with direct or eventual intent, and then specifies further in paragraph 3, a person acts with eventual intent when he or she is aware that a prohibited consequence can occur as a result of his or her act or omission, and he or she accedes to its occurrence. And this is now drawing on the legislation as published in the Official Gazette of the Republic of Kosovo on the 14th of January 2019, which is Gazette number 2, and there on page 5 and 6 for your honors as a source or reference. So even if we turn in our questions of whether next to attribution and causality, intent, questions of intent, the applicable mens rea are not drawn from customary international law, but we look to questions of Kosovan law, we do have a very clear answer here. Your Honours, I will not discuss all the questions that you posed in your recent order simply because I am here to represent the victims' interests, their concerns, and therefore limit my submissions to those most relevant points. But I do want to add one more observation in response to the defense submission yesterday that directly concerns them. The defense suggested, in a nutshell, that the trial panel had been biased and had applied double standards when considering witness evidence. And although Your Honours didn't invite a legal discussion of this, but to us it is very important to address this, as justice, of course, can only be done and seen to be done if a trial is conducted in a fair and impartial manner. And therefore, this, of course, is vital to the victim's quest in searching for justice and the truth. And this assertion of double standards, of bias, couldn't be further from the truth. And to illustrate this point, I want to take you, and indeed everybody, back to the start of the trial phase, in which closure without any undue delay. The importance of bringing this case to a close and the impact that closure will have on victims cannot be overemphasized. And with that, I actually want to just allow some of what victims told me when we met after the announcement of the trial judgment. One of those indirect victims said to me that this pronouncement of the judgment had felt like another funeral to them and to their family. And it was for them as if they were finally able to put their loved one to rest. And nearly every single victim participating here clearly expressed that the judgment, including the sentence, was perceived as a fair and a just announcement reflective of their experiences. Now, the participating victims place their faith in your honors, in the appeals panel, to render a just verdict here at this stage. One that will be another step for them towards putting the events of April 99 that have fed so many nightmares behind them. Thank you for your attention. Thank you.
We have one question.
Actually, I have many questions. Sorry.
More than one.
Thanks a lot for the very substantive discussion of the causation issue, and that you took it up to rewrite your submission. So if we have this scenario, which is a consequence of the application in due pro reo, that Serbian forces killed the victim, wouldn't you agree that this Serbian forces or the person who killed this victim would be responsible for murder?
Depends. It depends on the situation in which there was any fire, because obviously we know, well, it's a war. It's a wartime situation. Not every shot fired in a war equates to murder. It depends on whether it was a shot that was directed at him as a civilian. If so, yes. And if so, yes, we may have two different perpetrators committing the same crime, which can happen. But it doesn't, one doesn't overtake the other and disrupt the chain of causation.
Okay, that was actually a simple question. I think we do not have to expand on it. Exactly, that's the situation. If we start from this assumption, then we have responsibility on the other side of the forces. Of course, in this situation, is a clear civilian target or the combat if it were combatant. So it's no question actually. So it's absolutely clear, because you made the argument that you cannot distinguish between the cases where you leave a person helplessly behind and this person is killed by nature. This is a case law, actually the German case law, other case law, where causation has been affirmed and legal causation, and the situation where you have an intervening autonomous agent. And this I want to challenge, because what you perhaps forgot in your argument, that there is the other side. There is no impunity in these situations, because you will have responsibility. And then the only question would be if you have a kind of double responsibility, okay? In this case, in our concrete case, we have a responsibility of the defendant and you have a responsibility of the Serb forces. So that would be the legal question. And so that must be taken into account in the equation, in your argument. Wouldn't you agree?
Yes, I agree, but you can have two perpetrators committing the same crime or acting towards the same success. And then it can't just be left to coincidence of which danger now materializes more quickly on who is responsible for completed murder and who possibly only for, say, attempted murder. Yeah,
Yes.
that would be arbitrarily leading to results in which ultimately then probably you might have two attempts of murder, because you can't possibly say which is the cause that did this, which delivered this final last straw until death actually occurred.
Yes. So the next question would be, if you say it's reasonable and fair to impute the murder to the defendant, but how we deal then with these other cases? I have a variety of cases where someone is responsible for killing someone. I can shoot you directly. I can leave you in a helpless situation. We have case law on this, and you are killed because you are freezing at night or whatever. But here we have a situation, you know, for in due pro reo, that an intervening actor is acting. So you would treat all these cases equal, because you are saying, and the SPO too, that he is responsible for murder. And in any situation, if we had enough evidence to prove that the defendant had directly killed the victim, there wouldn't be a problem. We wouldn't not have this discussion. But this result, what you are defending, and also SPO, means that it's all the same. So there is no difference. What is then the difference between a situation, which we now discuss, and a situation of a direct killing?
See, if we go to some of the case law, actually you find quite a few examples where even where someone else then, say, to mind comes, for example, a German case, and forgive me for sort of the domestic lawyer coming up in me here, where even if someone else delivers another shot at the already heavily injured person as a sort of mercy to free themselves, even then you continue to have an attribution as murder, because you don't disrupt the chain of causation. It's not the see, in my view, we only the causation, or the disruption of causation, only comes in when you have something that is indeed entirely new, and it's not the intent of a danger that
I get your point. So then
unfolds.
please give me an example of when you would agree. We are talking about legal causation, not factual causation. Under what situation then would the chain of legal causation be broken?
If something entirely new, a new danger came to light, and I'm not going to dig through my notes now. But if, for example, say someone plants a bomb that hasn't gone off yet or anything, and someone else totally independently shoots this person before the bomb goes off, or can I think of a better example now? Not from the top of my head.
No, I think it's a good example. Thanks.
But
Thanks a lot.
it is one of those examples
Okay.
where you have not someone basically building on top of what has been
Yes, I
prepared
understand.
by
I
the
understand.
perpetrator.
It's very helpful. I have another question, because you made this argument of objective and purpose, and you know that we discussed this for the German speakers under Schutzzweckzusammenhang. And you made the argument that the purpose of the provision, and that's the question, what is the purpose of a murder provision? is the purpose of any murder provision, also in normal criminal law, the question is always, if you talk about purpose, is it the purpose to prevent this result from happening, i.e. the result that a third actor intervenes? Is that the purpose of the provision? Or is it the purpose of the provision to exactly prevent the result that the person which is on the dock, and the defendant in this situation, kills a person? So the argument of the purpose of the object of the provision is a double sword in a way, you know, because it could be interpreted the other way around. Maybe you can reflect upon it again. I mean, because in your submission, which I find very helpful, you didn't consider the responsibility of the third actor, and that makes perhaps things a bit more complicated.
See, in my view, the war crime of murder in this specific situation is perhaps a bit more complex than murder in the ordinary criminal law scenario, because we are specifically looking to protect civilians in times of war. That's what Common Article 3 tries to do. And this is where it tries to do so regardless of who acts on which side and what they are doing. And I think this is where we have to start by looking at the civilians rather than thinking about the perpetrators in the first instance, and trying to make it as effective a provision by preventing anybody from acting in any way that could lead to the killing of civilians.
So the last question refers to the intent again. You referred to Article 21 of the Kosovo Code, which clearly includes dolus eventualis. Actually, that was a door I wanted to open, but the SPO didn't jump on the door, didn't use the entrance. So thanks for having taken this up. But my question is the following. Article 12 of our law says that we can apply this as a substantive criminal law of Kosovo insofar as it is in compliance with customary international law. Now, if you say, generally, not you personally, but SPO and you perhaps, customary international law only allows for direct intent. Now, looking at the case law, we have a lower standard in Kosovo law. Would that mean that the Kosovo law is not applicable because it would be incompatible with customary international law? Just for you, I mean, there is a tension between Article 3 and Article 12. You should maybe reflect on that for the next cases. There is a certain tension in our law, but this is just the question now. The compatibility with customary international law of Article 21 of the Kosovo Criminal Code. Is it compatible or not?
It's a good question, but one which, when you try to give an answer to that, I am not entirely sure that they are quite as opposing as they are willfully. Well, how was it framed? As committing bodily harm, knowing that this could lead to death. Is this always direct intent? Is it not? Possibly you can't quite categorize it in the same way. See, I'm not sure that they are so far away from one another, because doctrinally they quite work in the same sort of language, so to speak. And this is why I think it's slightly more complex than just saying yes or no here.
Yeah, doesn't it show to us, and that's my last remark here, that it is sometimes not helpful to invoke customary international law, which by definition is very imprecise. And if we look at our Article 12, it's hard to answer sometimes, in this case and in others, the questions, when is Kosovo law compatible or not? Ask this question for your own law, French law, German law, US law, when is it compatible with custom international law? This implies that we have clear-cut standards in custom, and that's not the case. And that is actually a big issue for us here. But thank you very much for your very thoughtful considerations, and certainly very helpful for us. Thank you very much.
Thank you.
I think we are not finished with the questions.
Thank you. I had a question about modes of liability, other modes of liability. So in your submission, would it amount to absolving someone of murder? Those are the terms you used, or amount to unfairness if, for example, aiding and abetting liability would be applied in this context?
Do you mean, would it be unfair as in how victims
From
perceive
the
it?
perspective of the victims, yes.
Okay. I am not sure that the victims, because this is obviously I've got to marry sort of the perceptions and the views of lay people with my own legal positions here, but for them and how they received it, Salih Mustafa was more than an aider and an abetter, because he was the person in charge.
Okay, thank you.
Thank you. So that concludes, finally, your submission.
Thank
so
you.
We still have about 20 minutes. May I ask the Mr. Mustafa's counsel to make his submission, and if you need more time, we'll stop at 11, and then if you need more time, we can continue after the pause.
To be quite honest, Your Honor, it would be preferable to take a short break now, and that I can fulfill all the elements rather than doing it now, so that I can digest a little bit the rest and compile it.
I understand your point, but we have to check with the interpreters, because the idea of the pause is that the interpreters can have some rest after time. Let me check.
Interpreters note, we think having a break now would be all right.
It seems, and we'll reconvene at 11:15.
Thank you very much, Your Honor.
All rise. All rise. Please be seated.
So now I invite the accused counsel to make these submissions. You have more or less half an hour.
Thank you very much, Your Honor, honorable members of the court. I will discuss a number of the issues that have come up. Let me start with the issues that were brought up by the prosecution. The prosecution showed a document which was a list of prisoners. We have seen it, and that document, in fact, well, for whatever it is worth, it is not worth anything in this case, because the document does not indicate at all where the people were detained. And in addition, it did not say anything about the release of any of the enumerated people on that, at least not anybody who is relevant in this case. That document, Your Honor, was part of a file, and in that file there was on some other page an annotation, and that annotation indicated the name of a person called Salih. And here is what happened. Prosecution combined these documents and said, well, you see, he is in charge, or it is related to that document. Such relation has not been established, neither by the SBO nor by the trial panel in its judgment. Therefore, that document, as far as the defense is concerned, is not relevant and cannot bear, cannot be any evidence related to whether the accused was the one who detained people or where these people were detained and until when these people were detained. Then the SBO made submissions regarding the causation issue and extensive jurisprudence on that issue. However, Your Honor, the examples that the SBO gave regarding that are presumptions that equally were made by the trial panel. For example, that the victim was in the custody of Salih Mustafa. It is a presumption. Whether there was any contact with Mr. Mustafa and that victim is an equal presumption. Then that he was left behind for death or on the brink of death. For such assertion, there is no evidence in the case file. It is indeed a presumption. The refusal to release him is an equal presumption. The refusal to release somebody indicates some kind of positive action from somebody in order to make such judgment, whether that whether that person were to be released or not. The only thing we know is that people were released, and the people that testified here in court, they went elsewhere, and they had no further contact with this person. So whether the victim, the murder victim in this case, was released or not released is, and that would be even a decision of the accused, is a mere presumption and rests on speculation. Same with the denial of medical aid. What we know is that these people were in a barn, and wherever they were kept in the barn, in whatever location that might have been, they did not get medical aid. But that has nothing to do, or maybe we can only say something until the other persons were released. we have no information whatsoever what happened afterwards, and whether at that moment that person would have been denied medical aid. Denial also means, again, some kind of positive, specific decision. We don't know whether there was anything available, but we don't really know whether that was denied to that person. Maybe he got even medical aid and died. We simply do not know, and therefore that is based on speculation, and it's a presumption again. Another example that the SPO used was they refused to evacuate him. Who says that? We don't know whether this person was evacuated or whether there was a refusal to evacuate him. Such evidence needs to be established in the case. And lastly, there was the citation, or not the citation, but the paraphrasing, that witness 4600 heard that this person was dead. And indeed, 4600 testified about that. But in fact, we requested him, and we asked the question specifically, from who did you hear that then? Can be found guilty. But on the basis of these presumptions, I do not believe that the accused could have been found guilty. I turn to the sentencing part issue. The relevant applicable law at the time was Article 38 of the Criminal Code of Yugoslavia. That law provided under Provision 1 the following: the punishment of imprisonment may not be shorter than 15 days, nor longer than 15 years. The Provision 2 of the same article read, the court may impose a punishment of imprisonment for a term of 20 years for criminal acts eligible to the death penalty. The crime here, in this case, would be eligible for the death penalty. However, with the abolishment of the death penalty by UNMIC Regulation 24 of 12 December 1999, Article 1.5 of that regulation stipulated that the death penalty was removed. The regulation entered into force on the 10th of June 1999. The next step was that Regulation 24 was amended. The new regulation that came into place was Regulation 2000/59, dated October 27, 2000. Article 1.5 of the previous regulation remained in place. However, there came an extra article, and that was Article 1.6, and that provided a maximum term of 40 years for acts previously punishable by the death penalty. Section 4 of this UNMIC regulation provided a transitional provision regarding this regulation. It would enter into force on the 27th of October 2000 and specified that the new section 1.6 only applies to offenses committed after the 27th of October 2000. Therefore, taking into account the principle of prohibition of retroactive effect of the criminal code, there was no legal basis for imposing a maximum sentence for offenses committed before the 27th of October 2000, and therefore the CCFSFRY, so the Criminal Code of the Socialist Former Republic of Yugoslavia article, remained as the legal basis to impose a sentence of a maximum of 15 years for offenses committed before 27 October 2000. The defense provided in its appeal brief the judgment of the Supreme Court of Kosovo. In that judgment, we can read the exact position of the Supreme Court on the issue. That is the issue of the application of the law that was in force at the time of the offense of the indictment of Mr. Mustafa. And the decision, in its recent decision on this issue, said, and I quote, "With the UNMIC regulation number 1999/24 of 12 December 1999, which entered into force on the 10th of June 1999, the death sentence was abolished and no long-term prison sentences were determined as a substitute. So, no alternative death to the death penalty, a prison sentence of up to 15 years remained." The trial panel, in paragraph 781, which we just heard from the prosecution also, noted that the applicable law at the time was the criminal code of the former Yugoslavia. In the footnote, that it stated that the panel also notes that subsequent relevant laws or codes adopted in Kosovo provide equal or more sentencing ranges. However, the defense submits that the trial panel's observations on this issue is irrelevant. None of the subsequent laws are applicable. And I just cited the UNMEC regulation, and in the footnote, which we just earlier discussed, the other regulation, namely the regulations which did not which said that Article 1.6 would apply only to crimes committed after that day, and I'm referring here to Regulation 2000/59, which amends the previous regulation. That regulation clearly specifies that the new section shall apply only to crimes committed after the 27th of October. Signed by Bernard Kouchner, Special Representative of the Secretary General at the time. In any event, Your Honor, the UNMEC regulation cited in that trial panel's footnote 781, that footnote is incomplete because it left out this particular regulation. The UNMIC...
Excuse me, can
Yes,
I just
yes.
ask you again? The footnote is incomplete, you say, but the paragraph is still correct, no? Because you yourself quoted the code of the former Socialist Republic of Yugoslavia, and that's what was applied. So I don't understand exactly what is your point here, because, you know...
I understand your point. The point that I'm trying to make is that even in the footnote, it refers that subsequent laws were more harsh, so to speak, but that is not the case, because those came only into place with this amended regulation, and that regulation regulated only things from the 27th of October 2000 onward, but not retroactively. In that case, it would remain as Article 38 of the former Yugoslavia law, so to speak, which imposed a prison sentence of up to 15 years. So that is the trial panel also cited Article 150 of the Criminal Code of the 20th of April 2012, and that law is also not relevant for what we here speak about is obviously the Lex Meteor, as it entered into force only after 2013, on the 1st of January 2013. So, all to say, Your Honor, that the defense submit that the trial panel is bound by Article 44.2, but certainly by the Constitution, which enshrines Lex Meteor as well. And as stated earlier, the Lex Meteor is enshrined in the Kosovo Constitution, Article 33.2 and 4, and as stated earlier on, it is an international standard as well. And therefore, Your Honor, the trial panel erred in applying higher sentences for both the crime torture and murder, that is respectively 22 and 25 years. The trial panel exceeded the applicable law on punishment that is in violation with the Constitution, and that was basically the entire argument why this invalidates the judgment regarding the sentencing. Therefore, the correct applicable sentence at the time punishes the crimes with a maximum of 15 years. And let me just briefly address one thing, Your Honor. As we suppose or propose that it is well worth, in case the appeals court would be of the opinion that, or would be of the same opinion in the trial panel, we propose the constitutional compatibility of the law towards the Constitution. And in the same paragraph, it says that the Kosovo Specialist Chambers must apply or take into consideration, or no, shall apply, that is the correct wording, shall apply the Constitution of Kosovo. That is exactly why we have argued this. And this is, in order to get back to the Victims' Council, this is not at all any reason to stall proceedings or whatever. What is critical in this case is that the law that is applied is correct and that the truth is determined correctly. But when the law needs to... Yes, sir.
Excuse me,
Yes, Your
I
Honor.
really have to clarify this. I don't understand your argument. In footnote 1629,
Let me just get it.
I mean, one thing is that you are saying the trial panel did not make the test if there is a more lenient sentence applicable. Is that your argument? So then you must show that what has been quoted in 1629 is incomplete and there is a more lenient sentence under current Kosovo law. And so, you know, there are two arguments. One is,
Yeah.
where is the lex meteor violation here? I mean, there has been a comparison, as we have discussed before, in this footnote. You may say that it has been incomplete, but the trial panel tried to compare. But what is then the provision which gives you a lower sentence, a more lenient sentence than Article 38 of the applied provision, which goes up to 15 years?
Let me be once again clear, Your Honor. The argument stands as follows. We believe that Article 38 of the Yugoslav Code was applicable and only applicable. Let there be no mistake about it. Just, I wanted to show that in Article 1629, that the trial panel said that there were not more lenient sentences subsequently, but that in that case they did not see this particular regulation that left simply that part open. The death penalty was abolished, yet there was no new subsequent punishment installed for it. That was with that new regulation implemented. However, then they said that counts only for crimes after the 27th of October 2000. And therefore, in that perspective, the footnote is incomplete.
Yes, I understand, but the trial panel, wouldn't you say, Mr. von Bonnet, that the trial panel made the comparison necessary under our law and the Constitution because it tried to look for a more lenient law? That's what the trial panel did, didn't it?
Well, they certainly did not apply the more lenient law because that was...
Why? But you say, I don't understand, you say Article 38 is applicable. Yes. Where is the more lenient law here? Where? Can you quote, please, the more lenient provision in the Kosovo law which gives you a lower sentence? That would be more lenient law.
There is no more lenient law. We are agreeing on that because any subsequent law was not more lenient. Therefore, Lex Meteor dictates that we need to get to the most favorable law that was applicable at the time of when the events took place. That is the entire issue, and that is why I just spoke about footnote 1629 in perspective. And these issues, they have also been done, Your Honor, in case law of Kosovo. And one of the Supreme Court judgments in this case was that one of the 20th of March 2023. That was case number 2020-017-884, and the file number is 26/2023. And from that, and we have put this one into our annex. The Supreme Court of Kosovo on page 10, in the last paragraph, at that moment spoke about it. I just refer to it to you. It is on page 10, on the last paragraph of that judgment. Another case law from Kosovo regarding to this matter is the Darko Tadic case, Tasic case of the 31st March 2022, case number 1971, and that is a decision of the Constitutional Court. It is a ruling of the 5th of May 2021, and we have a Kosovo original available, but Your Honors, we will provide Your Honors with an English version of this, an English translated version of this document. Important in this regard is that the court in that case considered, and I cite paragraph 48, taking into account the principle of prohibiting the retroactive effect of the criminal code, as well as that there is no legal basis for imposing the maximum sentences, as well as the principle of applying the most favorable law, the Supreme Court finds that for all crimes, criminal war crimes and other criminal offenses committed before the 27th of October 2000, for which the code of the former Yugoslavia is applicable, the maximum sentence of 15 years. Now, Your Honors, I would still, apart from this local Kosovo, that is just two quotations of Kosovo law. If we look at cases of the ICTY, what could be basically an analysis, so to speak, or case law provides many times either murder under grave breaches, or murder under crimes against humanity, or we see torture, and in many of the cases, sentences were much more lenient than the one that we have until now. I take it for ICTI case, in the case of Kupreskic et al., the trial judgment, which is IT 95-16T. It's Mr. Drago Josipovic, who committed a murder to multiple people with a maximum sentence of 15 years, sentenced by the trial chamber. If we take a look at other case law, for example, the Kwoczka case, it's ICTY 9831T, that's Kwoczka et al. We see many times multiple murders, multiple torture. Kwoczka himself was found guilty for murder and torture, received 7 years. Kos for murder and torture, 6 years. Radic, 4 cases of torture. He received, with persecution and other elements and personal participation in all these crimes, he was sentenced to 20 years. In the great many other cases, such as Delalic and Mucic, I could go on. In the Kwoczka case, once again, Miroslav Kwoczka was found on 3 counts: persecution, murder, torture, sexual assault, rape, murder and torture murder under count 5 further, plus murder under count 9. He was sentenced to a single sentence of 7 years imprisonment. With Mr. Prcac, I spell Prcac, he was found guilty on 3 charges: murder, torture, beating, sexual harassment in the part of the persecution. Apart from that, murder as a violation of the laws and customs of war, and torture as a violation of the customs of war. He was sentenced to a single sentence of 5 years. Now, I could go, of course, endlessly on, and of course I understand, Your Honor, that you might say, well, you know, you pick that argument and you pick that argument, whatever suits your case. But what we do find, if we review ICTY cases, and I take case law, which is related a little bit to the time or the same time frame of events as we are speaking here. Here we are speaking in 1999, there it was 1992. People were sentenced sometimes 10 years after, and obviously sentence ranges changes. But the red line in there is constantly that it is about multiple murders that are committing if the sentences are to very, very high. And that is, in our case, I believe, we speak about a single murder here of one particular person, and that amounts to 25 years. And we speak about torture regarding 2 particular people only, in which the accused was committing it himself, the direct dolus, so to speak. At least the trial panel found that. So, in that sense, we see that the jurisprudence of the ICTY also is very different and much lower in case. In any event, Mr. Mustafa has pleaded from the beginning on that he was innocent to the charge. Excuse me?
I just had a question relating
Yes.
to the ICTY
Yes.
cases, because in your ground 9D of your notice of appeal, you allude to an argument that a distinction should be drawn between those who hold political office in terms of sentencing and those who
Yes.
don't. I was
Yes.
wondering if you could elaborate on that point,
Yes.
please.
Yes. Those who hold political offices, we see many times that there is some kind of extra responsibility, not regarding specific people, but even more to civilians in even the abstract manner of the sense. In the other cases, we see many times that it is the personal perpetrator, so to speak. If we take the case of, I think it is Krnoljević, I never know how to exactly. It is a prison, a huge prison at the time, in Bosnia-Herzegovina, I believe it was. It was the KP Dom prison, where people were either in higher office and were sentenced for the commission of crimes which were taking place in that largest prison at the time. So I think that there is indeed a distinction that is being made in ICTY cases as well, as when people hold particular offices, Ministry of Internal Affairs, which has a particular specific obligation towards its own population, or this kind of things. Here we are much more busy, so to speak, with perpetrators who are in the field, so to speak. And still, if I see the cases of the ICTY, and that is also an issue that I found very important to stress, the time is an element constantly coming back in that. Many times we have a perpetrator, he commits some crime, other people are standing outside, they saw the person, then later on they come back and they see that he is dead. Obviously, when the time is short or relatively short in that cases, a causal connection can be made. But if we have 11 weeks after a dead body of somebody who saw a person on 19 April lastly, we have a huge time gap, and therefore we cannot fill in the blanks, as I said in my argument regarding that. I hope that this is an answer to your question. And then I will conclude, Your Honor, because I think I even went over the time. Mr. Mustafa has pleaded not guilty from the beginning on. He doesn't know people. He has no knowledge of these people who were there. It is attributed in a manner that he finds, he resents clearly. It is people to him who are unknown. He even said that in court. My client says he doesn't even know you. And one of the victims' counsel even stated that this person was questioned over and over again. Yes, of course we question that person. It is a person who says, I just know he did it. But how do you know? And we constantly moved on that. How do you know that? From what? Did you see him? Or did you speak with him? Did you know him before? Or did you know him after? No, nothing to that effect. So that is why Mr. Mustafa finds it really wrong that he was convicted and found guilty, and that is that his sentencing, apart from that, is excessive and disproportionate. Your Honors, I thank you very much for your attention. I would like to conclude with that. Thank you.
Thank you, Counsel. I think we might have some more questions before we give the floor to Mr. Mustafa to conclude.
Oh, yes. Yes, I do have the citations of the transcript, Your Honor. I spoke about, thank you very much, the transcript regarding witness 4600. and we can see that on the transcript of the 24th of September, that is 2021, 4600 on page 767, line
So it's a substantial cause, substantial contribution. It's only by the application of some exception that I've referred to as the common law concept of novus actus interveniens, which is the conscious intervention of a conscious and voluntary intervention of a third person. So by that application, by the application of this common law principle, that could sever the chain. But even in common law jurisdictions, and we've provided some authority in our brief, even in common law jurisdictions, the novus actus interveniens principle does not apply to omissions. And so even if Your Honours found that novus actus interveniens is part of customary international law, that would not absolve Mr. Mustafa of his responsibility for an omission. And liability for murder on the basis of an omission has been recognized in other international cases. Again, there are citations in our brief. And in relation to the mens rea element, Your Honor could bear with me one moment. So there's a reference, and again we've cited this in our brief as well, to the ICTR judgment in the, and I certainly am mispronouncing the name, Tagerura trial judgment at paragraph 659. that the accused failed to act intending the criminal sanction consequences or with awareness and consent that the consequences would occur. And yes, so for the mens rea of an omission, that would be the applicable mens rea standard.
Okay, thank you.
Mr. Van Bonnet, do you want to answer that question?
Excuse me. Focusing on omissions, how would that overcome the question of new intervening events? Right. The short answer is, Your Honor, it makes no change, because even with omissions, there must be proof of that omission, and that is some kind of positive action of that omission. And that's why I cited earlier on the Tadic case, the paragraph I don't recall exactly, but in that case it says it must be clear that whatever act that was or omission resulted in the death of that person. So in our view, that needs to be proven. And the trial panel, in our view, did not. It just speculated on it. Denial, not releasing, not evacuating, all kinds of omissions for which there were no proof in our case. That is my answer, Your Honor.
Thank you.
I would like to ask SPO and defense as to the question we discussed before with the Victims' Council. How do you see the application of Article 21 of the Kosovo Criminal Code in light of Article 12 of our law?
Well, the key qualification there is that it has to be consistent with customary international law. So to the extent that there is a difference, then customary international law should prevail.
So is there a difference?
I don't know the answer to that, Your Honor. I don't have the provision in front of me. I'd have to look at it. We're happy to make further submissions in writing on that point.
Yeah, maybe there could be a quick submission within the next days on this.
Certainly.
The short submission, I mean, it would be important to have your views. If you could apply basically Article 21, that's a question, you know, in your view.
Certainly, we're happy to make further submissions on that in writing. But just to emphasize, Your Honor, my earlier submission that in the circumstances of this case, it makes no difference.
That is Article 12 of the law, of the KSC law, in relation to that new Article 21 that the Victims' Council cited. That is the question.
Yes,
Okay.
Kosovo Code, which allows for dolus eventualis.
Yes.
That's the main provision in the Kosovo law.
Yes. We would like to also make then a written submission about that, if that is possible.
Perhaps you should say the date, you know, for this.
That was a question.
That was a question, yes. That's it, yes.
So I believe it's the end of the questions. May I ask the parties, both parties, to give their written submission during the next 3 days?
Yes, Your Honor.
So today is Friday, before next Wednesday.
Yes.
Yes, Your Honor.
Thank you. So we will now hear Mr. Mustafa, personal statement, if he wishes so. You have 10 minutes, Mr. Mustafa.
Përshëndetje trup gjykuese, nderuara gjykatëse. Unë kisha me thonë që edhe praktikisht, edhe moral.
Your Honors, I want to stress that I morally and practically feel not guilty, although I was found guilty by the trial panel. I am convinced that I did not commit any of the crimes that I was charged with by the prosecution. The prosecution has the evidence, all the evidence, and knows exactly what happened, and it's not even that close to the reality that happened. The prosecution, the trial chamber refused to look at the statements that were taken by the SPO. I'm quite certain that morally and practically I'm not guilty. If you have any question, I'm here to answer them.
We have no questions. Are you finished?
Yes.
Okay, thank you. So this concludes the appeal hearing in this case. So before we adjourn, I would like to take this moment to thank the parties and participants and the registry for their work on this case and their attendance today. I would also like to express my gratitude to the interpreters, stenographers, audiovisual technicians and security personnel for their excellent assistance. The appeal panel will render its judgment in due course. The hearing is adjourned.
All rise.